Good day, everyone. Uh, Today I'm going to try to teach you how to draft a simple motion in California. I've provided you with an example motion. You might want to print that out and follow along, or at least open it up. Okay. The motion, first of all, let's talk about what a motion is. A motion is merely a request for a court order. Okay. What we're doing is we're going to court and asking the court to do something for us. Okay, so in order to draft a motion, there are generally three things we need. We need a motion, a notice of motion to let the other side know what we're doing. We need a memorandum of points and authorities. That's going to contain our law and our argument. And then we need a declaration. A declaration is where the facts of our motion come from. The declaration is our evidence that we're presenting to the judge. Now, a lot of people think that motions are all about really oral argument, but the fact of the matter is most of the time oral argument, unless the case is close, really isn't important, because the judge is going to read our motion, he's going to see our law, he's going to see our evidence, and he's going to make a decision on that. Okay, so I'm just going to deal with the motion today. Now, what the other side's going to do is they're going to probably file an opposition to the motion. And I'm not going to really get into opposition to the motions. I'll probably post an example for you so you can see what one looks like. But we're just going to deal with actual making a motion, and specifically under California law. Okay, the motion that I provided for you is probably the most common motion made by civil litigators such as myself. Okay, and it's called a motion to compel. Now, what are we compelling here? What we're compelling is responses to discovery that we have propounded in the case. Okay, I don't have to get in, I can't get into all the details of discovery at this time. That's better left for civil procedure. But we have a right to ask for questions and documents and things like that from the other side. And then if they ignore us and don't provide us with a response, then we can go ahead and ask the court to order them to do so. Okay, that's the order that we're asking for. Make them respond. Or at least if they don't respond, make them kind of in trouble with the court, so down the road we can set ourselves up for a better position down the road. Okay, so let's look at the motion that I provided here. Okay, at the top is going to be the attorney's name. Okay, similar to pleadings and things like that. Okay, then we have the name of the court. This one happens to be one that I did, almost 15 years ago from Ventura, but it's a short, simple one, and that's why I chose it. Okay, then we have the bird cage. Okay, which has the parties and all that in it. And then if you look to the right of the birdcage, there's going to be the case number. I've left that blank for confidentiality reasons and things like that for my past client. And then we have the title of the motion. Okay, you can see there it's generally done in bold and in caps. This is a notice of motion and motion plaintiffs to compel responses to form interrogatories, which are written questions, and demand for inspection of documents. In this case, we asked them questions and we asked for certain documents, and they blew us off. So if they blow us off, what's our recourse? Well, to go to court and kind of force them to, or at least tell the court, have the judge tell them, you need to respond or bad things are going to happen to you in this case down the road. Okay, and then we have, in this case, I've requested sanctions. Okay, sanctions are money that we want them to pay because we had to waste the time to go to court and get this motion. And believe me, courts do not like having to deal with motions to compel. The other side should respond, and if they don't, the judge isn't going to be happy. Okay, now, as a general rule, I do not request sanctions against local counsel. Okay, this is kind of an unwritten rule here in Kern County that unless they've really kind of jerked us around, if they're local counsel, we won't do so. And the reason is a lot of times it's not the attorney who's dragging their feet, it's the client. Okay, but in this particular case, I'd been jerked around enough that I decided to request sanctions from local counsel on the other side. Okay, even though this case is in Ventura, the attorney on the other side happened to be from Bakersfield. So it's kind of a rare incidence that we're going to ask for sanctions, but in this case we did. Okay, and then the declaration of Jay Jamison, okay, which is me, and that's where we have our evidence to support our motion. So below the title of the motion, we put the date, time, and department. Sometimes you'll see place instead of department of the motion. Now, how do we get that? We call ahead to the court. And some courts just say, go ahead and set your own date. Other times you have to call ahead. So make sure you know what your particular local rule is or local custom is in your particular county on how to set the date for the motion. Okay, it has to be set far enough in the future to give the other side time to respond. Okay, generally that's 10 days or 15 days plus 5 for mailing, depending if you're in state or federal court. Okay, so that's how we get our time. And then the department is normally going to be the department that the case is assigned to. In places like Kern County, one courtroom handles the whole case. In other courts, bigger courts, maybe a different judge than is actually going to be hearing the case or trying the case will hear the motion. But I don't really have time to get into the specifics of that. But just understand, different courts do it in different ways on who's going to actually hear the motion. But in Kern County, it's going to be the same motion. It's going to be the same judge that's going to try the case for me if the case goes to trial. And, at least gets them in mind that I'm on top of things. The other side's dragging their feet. And, so that's kind of a good thing if you have the same judge. At least to let you know I'm at least doing my job. Okay, so let's go into the notice of motion, okay, which is this first and second page of the motion, okay. Here it says to defendant, blah, 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 and their attorney of record, okay. If I represented the defendant, it would say to the plaintiff and their attorney of record, okay. And then we generally start out, notice is given that a particular day, at a particular time, in a particular department, and the address of the court, here it's in Ventura, that the plaintiffs or the defendants, it really doesn't matter, will move for an order. An order is something the judge tells them to do, compelling the defendant to serve responses to the discovery that I have already propounded in the case and they have not responded to. Okay, in this case, it was demand for inspection of documents, as the date I served it, and form interrogatories, which are written kind of questions that I also served on the defendant. Okay, also, if you're going to ask for sanctions, you have to put that in the motion itself. Otherwise, the judge will not award them. Okay, so notice is further given that we'll be asking for sanctions. Okay, now sanctions are kind of a bummer for the other side because the attorney generally has to pay them out of his own pocket, or at least get the client to do so. Excuse me for just a minute. My dog walked in the room and now I got to kick him out.